Straight ahead on Law and Crime Daily. Rape allegations against an international soccer star. Could Cristiano Ronaldo go to court over hush money payments?
Plus, a grand jury wishes to speak publicly in the killing of Breonna Taylor. Our experts react to claims by Kentucky's Attorney General.
It was like she was an afterthought, and it angers me because it keeps happening.
Also, one of the Minnesota cops accused of murdering George Floyd is out of jail. And is it graffiti or urban art? A legal victory for those who spray paint. Law and Crime Daily covers court cases from coast to coast. And welcome everybody to Law and Crime Daily. I'm Aaron Keller along with Brian Buckmire and Terri Austin. Let's go to dramatic video right off the top now of a man accused of kidnapping a 9-year-old girl in Providence, Rhode Island. Police there releasing this surveillance video they say shows the girl being abducted from her bus stop Monday afternoon. Officers say the driver of a silver Nissan SUV grabbed her off the street and pulled her into the back seat before driving away. The girl was dropped off about an hour later at a nearby location. The suspect, Luis Martinez Romero, is facing charges of kidnapping a minor and second-degree sexual assault. He's being held without bail. Let's go to St. Louis, Missouri now, where a grand jury has indicted the couple caught on camera displaying guns and shouting to protesters outside their gated mansion this summer. Law and Crime Daily's Terri Austin is here with that update. Terri.
An attorney for Mark and Patricia Peklowski says the couple now stands accused of the unlawful use of a weapon and tampering with evidence. But the couple's attorney says prosecutors tampered with evidence by assembling a pistol, seized as evidence, in a way that could be fired. He says that is prosecutorial misconduct. The couple claims self-defense after they brandished their weapons as protesters entered their gated St. Louis community this past June. Former federal prosecutor Gene Rossi helps us break down the grand jury's indictment.
Okay, for the first charge of brandishing, the couple has a self-defense argument. There were allegedly protesters outside that were threatening them, yelling at them. This is what they may say. And they were fearful. The gate was pushed, allegedly. So they held those guns to defend themselves and their property. You can defend yourself. Your property's another matter. But they may have a self-defense case. But the tampering issue, that one is going to hurt them at trial because jurors understand self-defense. They don't like tampering. And what tampering shows is consciousness of guilt, and it's a relatively easy charge to prove.
The attorney for the family of a man killed by police in Texas is calling for video of the incident to be released. Attorney Lee Merritt says Jonathan Price was trying to help a woman in a domestic violence situation at a convenience store. According to a newly released probable cause statement, Price was trying to shake hands with Wolf City police officer Sean Lucas. Lucas says he thought Price was intoxicated and tried to detain him. Body camera video reportedly shows Price walking away as Lucas deployed his taser. Price apparently then walked towards Lucas and appears to grab the taser when the officer shot Price. The Texas Rangers are investigating the case and say the officer's actions were not reasonable. Lucas was indicted on murder charges. The officer's attorney told local reporters after Mr. Price refused repeated instructions and physically resisted, Officer Lucas deployed his taser and continued to give Mr. Price instructions. Mr. Price resisted the effects of the taser and attempted to take it away from Officer Lucas. Officer Lucas only discharged his weapon in accordance with Texas law when he was confronted with an aggressive assailant who was attempting to take his taser. That's from attorney Robert Rogers. Let's jump in for some analysis now. Brian, the details of this case are still coming up. Is this reasonable or not for the officer to have acted this way?
Let's put it this way. When the police department comes out with an indictment this quickly, and they affirmatively say that based on their views, this is not reasonable, it doesn't look good for the defense here, that being the officer. And to be honest, I'm sick and tired of being sick and tired because we're always hearing that there's some reason that officers can respond to not listening to commands with deadly force, and that's not what the law says.
So Terri, when you look at this from the perspective of reasonableness or non-reasonableness, because that's some of the standard here, we have to look at this objectively. Does it make sense that the officer would pull his gun and then fire, given that, according to the video apparently, at least as it's relayed in the charging documents here, that the person who was shot, who became a victim, was trying to take the taser, because we all know what the officers say. They try to say, well, if he gets the taser and uses it against me, then he can take the gun, and we hear this story roll out in a number of cases.
Well, that's exactly right. We've heard it roll out in too many cases. The fact that the person is trying to take the taser and the fact that the officer responds with deadly force. And frankly, I don't think any of this is going to change. We see some changes in the law, but we don't see any change as far as the accountability of the actual police officer is concerned. So we need to see them charged, indicted, convicted, and jailed.
So, Brian, again, if we go back to this, is it reasonable at all for the officer to say, I feared for my life because this guy was trying to take my taser?
So when it comes to self-defense, reasonableness is a two-part test of objectiveness and also subjective. Subjectively, yeah, I'm sure this officer was fearful, but objectively, we're going to have to wait to see the video to really answer that question.
Exactly. I'm waiting for the video to come out here again. That's why we've got the family saying we need to see the interaction, because the story may change depending on how long or how short this interaction occurred. The ex-Minneapolis police officer charged with murdering George Floyd is out of jail on a $1 million bond. Derek Chauvin was released on a conditional bond from the Hennepin County Sheriff's Office. He's the last of 4 officers charged in Floyd's death to actually post bond. Chauvin has been in jail since May on charges of murder and manslaughter. Video captured at the scene shows Chauvin kneeling on Floyd's neck for almost 8 minutes. The 4 former officers facing charges are scheduled to face a jury next March. Prosecutors are asking the U.S. Supreme Court to affirm the death sentence for the Boston Marathon bomber. The First Circuit Court of Appeals ruled that Zohar Tsarnaev would spend the rest of his life behind bars, but that his death sentence needed to be thrown out. The Circuit Court decided that what it called extensive and sensational pretrial publicity was not properly dealt with during jury selection or during motions for a change of venue outside of Boston. The appeals court said the local jury was neither impartial nor indifferent. The government is hoping to have Tsarnaev's death sentence reinstated without a new trial. 3 died and 260 were hurt in the 2013 bombing. And still ahead on Law and Crime Daily, we'll tell you which charges were dropped and which ones weren't in a case against a lawmaker charged with protesting the killing of Breonna Taylor. And later on, world-famous soccer star Cristiano Ronaldo is in legal trouble in the United States over hundreds of thousands of dollars in payments he made to a rape accuser. We break down the controversy when Law and Crime Daily continues. Kentucky's Attorney General is being asked to respond to a lawsuit by a member of the grand jury in the killing of Breonna Taylor. The grand jury convened in secret last month. One officer was indicted for wanton endangerment for firing into Taylor's neighbor's apartment. No officers were indicted over Taylor's death. Now, an unnamed member of that grand jury has filed a motion to speak freely about the case, saying they want to make sure the truth got out about the proceedings. Kentucky Attorney General Daniel Cameron answered questions about the indictment at a press conference recently and defended his actions.
Statements that were made by officers there the night or the morning of March 13th show that they did knock and announce. The important point here is that information was corroborated by another witness who was in close proximity to apartment 4, who corroborated that information and said that there was a knocking and announcing by the officers. Our team walked them through every homicide offense and also presented all of the information that was available to the grand jury, and then the grand jury was ultimately the one that made the decision about indicting Detective Hankinson for wanton endangerment.
Law and Crime Daily's Brian Buckmire listened to 15 hours worth of those grand jury proceedings. That's what's been released thus far, and found some discrepancies with Cameron's statement. Brian?
Yeah, Aaron, the prosecutors barely mentioned Breonna Taylor's name during their presentation. Had I not known the story beforehand, I wouldn't have really known this case even involved her. Although the prosecutors' legal arguments were not made public, it's hard to believe Attorney General Daniel Cameron's team presented any other charges aside from wanton endangerment against former officer Brett Hankinson. Criminal defense attorney Eklund Mercy, who's not involved with the case, tells me she was shocked at how the proceedings played out.
At the moment in which we have one witness saying one thing, another 11 witnesses saying something else, that's a jury question, and that's something that should have been presented to the grand jury. And so it should have been presented at trial. And my issue is that he came in trying to be a defense attorney to the police officers, and we have a problem. That's the problem. He stated that he presented all the homicide charges. To have a grand juror so moved, so passionate that he did not do what he said he was doing to even hire an attorney because he lied is a problem. He should stand down. He should recuse himself. This was a gross misuse of justice. At the end of the day, even if the officers were found not guilty at trial, they needed their day in court. Breonna Taylor needed her day in court, and she wasn't granted that, and that's the problem.
In a related case now, felony riot charges have been dropped against a Kentucky state representative and 17 others who protested the indictment that we were just talking about. Lawmaker Attica Scott is best known for her proposed legislation called Breonna's Law, which would ban no-knock warrants if it's passed. She was taken into custody on September 24th as she joined a group of protesters in downtown Louisville. The protesters said they were on church grounds as of 9 p.m. That's when a curfew is due to set in. Scott is, however, still facing 2 misdemeanor charges of failure to disperse and unlawful assembly. So, Brian, as for this legislator's case, this is just very odd that you try to pass a reform bill and then suddenly the police move in and arrest you and you face felonies and misdemeanors. The good news for her, from her perspective, is that the felony is gone. So it's just lesser counts now, but it's still important. It's still serious.
Absolutely. And for most cities that have protests, myself being in Brooklyn, typically how these cases get worked out is once the limelight is gone, the prosecutor often gets rid of the cases because, especially for this type of story, Breonna Taylor, I don't see a jury of 6, if it's a misdemeanor or more, convicting her of any crimes.
And Terry, as to what Eklund Mercy, our law and crime analyst here, who joins us frequently, said about how this process played out, I have to look at it through Eklund's perspective here and say, hey, look, you know, where was the rest of the case? Because it sounds like it just wasn't there.
Well, that's exactly right. And Eklund makes an excellent point. The grand juror who came out, made a motion, got a lawyer, because all of this evidence wasn't presented. That is so unusual. It's unusual for us to hear the record, actually. It's unusual for a juror to come out and say, we weren't presented with all of that. And this case is unusual because it's taken so long even to get to the grand jury. And then finally, obviously, the fact that the charges against Hankinson don't even deal with Breonna Taylor. So this case is really unusual.
Brian, I forget the exact quote, but there's something along the lines of the greatest burden that your soul can bear is an untold story. It sounds like that's what this grand juror has, and they want to get it out.
Exactly. The way that Attorney General Daniel Cameron presented this, as I think even Gene Rossi said earlier, is that this was not how a prosecutor speaks about a case. It's not how a prosecutor presents a case. As I said as well, if prosecutors present cases like this, I'm out of a job because he was more defense attorney than prosecutor.
Wow. Brian Buckmire worried about his career potentials here on Law and Crime Daily, but point well taken. Well, later on in our broadcast, we're going to break down a complicated rape accusation against the world's second highest paid athlete, and legal graffiti artists mark a legal win against a building owner who they say destroyed their legitimate art. The federal law that was on their side when we return on Law and Crime Daily. A legal victory for legal graffiti artists in the New York City area. The U.S. Supreme Court has refused to take a case filed by artists who displayed their work at the Five Points site in Long Island City. The High Court's rejection leaves in place a Second Circuit Court of Appeals decision, which ruled the Visual Artists' Rights Act applied and that aerosol artists had certain rights in their work even though they didn't own the building it was attached to. The building's owner originally agreed to turn what the Second Circuit referred to as his dilapidated warehouse buildings into an exhibition space for artists. The artists actually rented space and spray painted the building. So, Brian Buckmire, that's one of the keys to understanding this case. This was not illegal graffiti. This was a legitimate contractual relationship among an owner of a building or a complex and artists. And that's why the art enjoyed legal protection and didn't end up with the artist becoming your clients in criminal court.
Exactly, and Aaron, it even goes beyond that. I mean, I went to Queens College in Flushing, New York, Queens, and if you took the 7 train into the city, you saw this magnificent artwork that once was dilapidated property that no one wanted to look at. We turned away when we were on the train, and it was something so gorgeous and so beautiful that the whole community was really rallying behind them.
So, Terry, the statute here gives artists, and it can be any artist, we have to keep that in mind, certain rights against the destruction of their works. But that's only if the works have achieved recognized stature. Brian just explained some of the recognized stature here. He knows this project, he knows the facility, he knows the building, he knows the art. Can you explain the law here a little bit?
Well, the law is only going to protect that artwork if, in fact, to your point, there is some sort of agreement, and in addition, that the artwork and the artist have some sort of stature in the community. So it can't just be a mark on the wall. It has to be something that people have looked at, they have respected, and the artist has to be honored in that regard. So it's certain types of artwork, not just any old graffiti.
And it was interesting, Brian, because the decision talks about how the art was changing at this facility, where there were some pieces that were considered always important and always to be there, and other parts of it were changing. So that plays into that legal argument.
Exactly. It was an interesting aspect as it applies to the law, because for the community and that statute part that I'm really talking about in the end there, it grew, it developed, it was organic, and we all knew in Queens what it was, especially people who went back between New York and Queens, Manhattan and Queens, sorry. I think it very much fit the statute here, and I'm glad they got that legal win.
It's certainly an interesting argument. Let's check in now with Law and Crime Chief Investigative Correspondent Brian Ross with what he's working on this week. Brian.
Thanks, Aaron. Coming up this week on Brian Ross Investigates, with the consequential election just 1 month away, growing concerns that the results could be compromised. We'll talk with the former head of national security at the Department of Justice about his greatest fears.
Their goal is to turn Americans against Americans.
That's this week on Brian Ross Investigates on the Law and Crime Trial Network. Back to you, Aaron.
And when we come back, a couple of cops in Maine are on the other side of the law facing charges involving the killing of porcupines, and it's causing quite an uproar. We'll explain when we return. Two police officers in Maine are now off a local force after a third officer is said to have recorded them beating wild porcupines to death with their police batons. And it all apparently happened when they were supposed to be out solving crimes. 27-year-old Addison Cox and 30-year-old Michael Rollerson are accused of sharing videos of themselves killing the animals on internal police department Snapchat channels, which were supposed to be used to boost employee morale. They've both been fired and are both now charged with aggravated animal cruelty and other counts. Rollerson admitted he pepper sprayed some porcupines, similar to ones you're going to see in just a moment, pictured at a zoo, and admitted he probably killed somewhere around 8 animals. Cox admitted to killing about 3 porcupines after ironically being pictured rescuing other animals on his department's Facebook page. The officer accused of making these recordings claims he didn't do it. Before news of the charges broke, but after kicking the officers off the force, the local police chief seemed agonized that he couldn't say more. Maine's laws relating to employee discipline do not allow those details to be released at the time. I follow the law. A tremendous amount of power is given to those who wear a badge and are tasked with protecting their communities. It's a power that I do not take lightly. I'm asking you to trust that if there were an allegation of police misconduct, I would take it very seriously and any investigation would be conducted appropriately, always placing public safety and community trust at the forefront. That statement was dated last week. Since then, the charges were filed and the reports are starting to become public. International soccer star Cristiano Ronaldo might be heading to trial over a rape accusation that's more than a decade old. Ronaldo is accused of assaulting a woman he met at a Las Vegas nightclub in 2009. Police reopened the case in 2018, but prosecutors later said they would not pursue criminal charges due to a lack of evidence. Up for question now is whether the woman who accused Ronaldo was mentally capable of entering into a $375,000 non-disclosure agreement in 2010. Ronaldo lives in Portugal and plays for an Italian soccer team. His lawyers say sex occurred but was consensual. The accuser alleges battery, coercion, and fraud. A federal judge in Nevada will hear arguments in November and could set a trial date. So, Brian, we're talking about one of the top soccer players in the world here, one of the richest athletes in the world. How can we be assured that this case gets a fair investigation?
So it's ironic when we talk about athletes in America because oftentimes they're such held to a higher standard, but because I think soccer's not that big of a country. I know, Aaron, you and I are even talking about Cristiano Ronaldo, and we were trying to compare notes. I don't think he's going to get that level of status that Aaron Rodgers or someone else in this country would. This is a claim simply about a contract, though, where she's asking for $200,000. For a man who's worth $450 million, I would assume he'd probably settle before anything else.
So, Terri, it seems as though judges are overriding these non-disclosure agreements more and more these days. Do you think the civil case has grounds to move forward?
I do. I mean, I think that the confidentiality agreement, it all depends on what is in there. You know, she's claiming that he shouldn't have allowed the information to be published. He's claiming that he had nothing to do with it, that it was all hacked. So depending on what the confidentiality agreement states, I think she has a very good chance of winning that civil action and winning, to Brian's point, the amount of money that she's asking for, the $200,000, because based on what he's making, that's just a drop in the pool.
We've got a lot of dollar amounts flying around here. We've got non-disclosures, we've got other accusations for settlements and whatnot, so it'll be interesting to see exactly how that judge rules. Brian and Terri, good to be with you here on Law and Crime Daily, and thank you for joining us. We'll see you back here next time to discuss justice in America.